Hello everyone and welcome back. In this video I want to talk to you about the Baker Act and what even constitutes criteria for a Baker Act. And the reason I'm making this video is because we're seeing just a bunch of cases coming into the office where people they clearly don't even meet criteria. It's not even a close call. And so I thought I would make a video and just run you through what the criteria are. And I'm going to give you the statute numbers that I'm referring to so that you can go and read this for yourself. So the first section of Chapter 394 being the Baker Act statute, is 394.463. And in there, it gives you the criteria for involuntary examination. Now remember, don't forget, there's two types of Baker Act here in Florida. Involuntary, which is the one you would associate with a 72-hour detention, and voluntary, which, if you've seen any of my videos, you will associate with an indefinite detention with no clock ticking, no court order needed to keep you. And I'm not going to go over that today, but we're going to talk about involuntary examination, involuntary detention, which is initiated one of three ways. Law enforcement can initiate the detention, a qualified professional like an emergency room doctor or a clinician, or somebody goes to the courthouse and files a petition and the court, a judge, issues an order for involuntary examination / involuntary detention. But here, this is the important part to note. 394.463, subsection 1, criteria. A person may be taken to a receiving facility for involuntary examination if there is reason to believe that the person has a mental illness, and because of his or her mental illness, and then it goes on to give the rest of the criteria. The important part to note is that the Baker Act is for somebody that is in crisis because of mental illness. Well, what does mental illness mean? What is that definition? So if you go to section 394.455, that is the definition section of the Baker Act. And if you scroll down to section 28, that's paragraph 29. Paragraph 29, which defines mental illness. And I'm going to read this to you. Mental illness means an impairment of the mental or emotional processes that exercise conscious control of one's actions or of the ability to perceive or understand reality, which impairment substantially interferes with a person's ability to meet the ordinary demands for living. And this is what's really important here. For purposes of this part, the term does not include a developmental disability, intoxication, or conditions manifested by dementia, traumatic brain injury, antisocial behavior, or substance abuse. So in the definition section here of the Baker Act, they're telling you not just what's included, but more importantly, what is not included, right? For instance, somebody who has a drug issue, right? They get Baker Acted. Somebody who's got dementia, and I've had a case like that, an elderly gentleman who had dementia who went into the hospital and got Baker Acted. A traumatic brain injury. Perhaps somebody was injured in a car accident and suffered a traumatic brain injury. They were concussed. Okay? Those are the types of things that are not included in the Baker Act, and yet we see it happening all of the time. And those are the kinds of things that are an illegal involuntary detention. And yet people are getting Baker Acted for those reasons. Why does it happen? Well, a couple of reasons. Number one, nobody knows you're there, right? There is no oversight here. Nobody is looking down saying, oh, you guys got it wrong, unless, of course, you call us and I drag them into court. And the second reason that it's happening is because even when they do it wrong, even when they do it illegally and violate your rights, you cannot sue them for this. You're not getting any money. Unless, of course, God forbid, you got physically injured. And I'm talking about broken bones, things of that nature. I had a client who was sexually assaulted in a facility, those types of things. But if you get bruises because the police, when they took you there, the cuffs were too tight and they bruised you, I'm sorry, there's no case there. And I'm not saying what was done to you was right. In fact, far from it. It's horrible. It's happened to my family member, and I wish it upon absolutely nobody. Okay? But the statute is very clear. Even if this is a private facility, because they are a licensed agent of the state's mental health system, they enjoy sovereign immunity. You can't sue them, and it's in black and white right there in the statute. You're not getting any money. I wish I could tell you that you were, because I would have been retired years ago. I'd be living on a beach somewhere in the Bahamas or wherever. I get at least 1 or 2 calls every single day from folks whose rights were violated and who clearly didn't meet the definition, clearly didn't meet criteria for illegal detention. So, as I have said in maybe every video I've ever put out there about the Baker Act, if you get detained, the time to fight is as soon as you have been held, okay? You got to get out as quickly as possible because bad things happen to people in Baker Act facilities and there's literally no recourse for any of these things. So fight to get out as quickly as you can. And that's my 2 cents on the criteria for the Baker Act. I appreciate you tuning in. I would love a thumbs up. And if you could subscribe to the channel, I'd be even more grateful. I appreciate you, and I'll see you in the next video. Goodbye.